I'm not hearing this matter.
Yes.
But I am of the view that, because when I look at the quantum being claimed, right, and I'm not minimizing the SIU case. If the tribunal finds that the PP items were delivered, which is another hotly contested issue,
yes,
then clearly the SIU is not entitled to the 400,000.
My lady, it's arguable.
Yes, wait.
Yes.
If delivery is proved,
yes,
it's okay. It's unlikely that the SIU will be able to establish a case for that, for a relief that amount.
Yes.
Right. And then the first and second respondents have attached, they've disclosed the invoices in relation to the PPE items they allege they supplied, delivered to the municipality. And the value of those is approximately 200,000.
That's correct.
Right. So the default, if the court finds that the award of the contract was irregular, and it considers setting it aside in terms of Section 1721A of the Constitution, then the court has to determine just and equitable relief. Right? Even if collusion is proved, remember, benefit has passed. So even if collusion is proved, the court will have to determine just and equitable relief. And the court will not ignore the benefit that has passed. It will not ignore it, right? So the quantum that will then be contested is an amount of 200,000. The court will most likely postpone the matter, and this is what I'd like to avoid, that further postponement of the matter, and hence I'm addressing this to you. The court is likely to then, call for an accounting exercise for the first respondent to account for its profits, which is likely to be it's an expensive exercise. It's likely to be an expensive exercise because the court is unlikely to just rely on the first respondent. So it will want some kind of audited, financial statement, particularly if the first respondent alleges that it incurred further expenses. And it already is saying that, salaries and stuff, So I will direct that this issue is ventilated by all the parties so that when the matter does come before the tribunal, then, the court is in a position to rule on just and equitable relief.
So, my lady, if I understand you correctly, there must be an investigation by the parties into the profit. The accounting exercise must be done.
I'm concerned that exercise is an expensive exercise. And what quantum will then remain?
Yes.
Be paid back to the municipality.
Okay. I hear you.
Yeah, if the parties can just apply themselves to this question, and if any party would like to supplement their papers to deal with it, in order that accounting exercise be done. Because I'm just concerned, because the SIU wouldn't want to incur more costs than it recovers, right?
Yes, my lady.
Yeah.
I hear what you're
And
saying.
this is an issue I would take into account to determine if I find that the delay is unreasonable. If I were to determine whether I should overlook it, it's an issue I would have asked you to address me on and to file supplementary papers on. Not necessarily to do the accounting exercise, but perhaps at this point, the first respondent would rely on its own accounting records to just make out a case that there's likely to be very minimal or no recovery here, bearing in mind the legal costs as well.
Thank you, my lady. I will take this up with my attorney and client.
Any counsel would like to raise any issue in relation to the debate I've had with Ms. Ibsen? No one.
My lady, excuse me, we are in the court's hands with regards to the further conduct of the matter. And I think it's the suggestions put forward in inverted commas, the directives are prudent in the sense that they would address the issue of just and equitability, whichever way the court will go with regards to whether or not the money needs to be paid back or any restitution needs to happen. So we are in the court's hands, and we will definitely undertake the exercise to deal with the costs incurred in delivering the PPE and also the related costs to the contract.
Yes, and what would also assist if parties just disclose their legal fees to this point?
Yes.
Yeah.
Okay.
Yes. Okay. Anyone else?
Milady, I'm going to come in here. I think I may be the most junior counsel in the room, but I'm coming in because no one else has yet. Milady, I appreciate that you're not intending to issue any particular order or directive today that you've told us. And I'm not going to try and argue for any specific directive today. However, I just want to record that insofar as it may come down to a decision between either getting translated copies of Afrikaans affidavits or text versus getting a different judge who could understand Afrikaans, our position would probably be to get the translated text, because the problem that can arise is where a judge translates Afrikaans text differently to how we do. And that becomes problematic. So obtaining then official translations avoids that conundrum because we're all on the same page of what the translations will be. I just want to record that now, just to say that that's probably where we're going to go. But I think the idea will be this matter is postponed, that the parties are going to engage with one another and we're going to come to some sort of mutual agreement as to the further conduct of this matter.
Yep, except that I don't think there's any judge who's going to do any translation. I'm referring to a judge who will read and understand because they are proficient in Afrikaans.
Yes, Justice, I understand that, but my point is that how a judge may understand the Afrikaans text may be different to how we understand the Afrikaans text. So all I'm saying is it would be better if we could have an official translation that we all agreed to is the correct translation.
I'm just concerned about the costs here.
No.
I'm concerned about the costs here because the quantum, even the 400,000 is not a large quantum.
Milady,
Right.
I've just entered the stage. I share your ladyship's concern with reference to the audit, but in addition there to have a proper transcript or a formal transcript done is simply adding additional costs. But over and above, with reference to my learned colleague's point, Mr. Prinsloo, I don't quite understand the point, because whether the documents, either in English or Afrikaans, a judge will have to read that particular document and come to an interpretation. Even if it's written in English, it might not accord with my interpretation. But so to argue that that's a basis for translation of documentation, especially when voluminous, is maybe not the most cost-efficient way of setting about this matter. That would be my response to any idea of there being formal translations as opposed to the matter being handed, as your ladyship says, to a judge who is able to deal with Afrikaans. Thank you, my lady.
Thank you.
My lady, on behalf of the fifth respondent, we are also very mindful of the cost issue. So our position would be that will be the last resort, the translation, because in any event, that cost, somebody would have to pay that cost. And if it can be avoided,
Yeah.
we would rather opt for the option where a judge can read the papers rather than incurring the cost. But we are in the hands of the court in this regard.
Thank you.
Thank you, Justice. Justice, as I said, I don't have any intention of arguing the point on how we should go forward in this matter. I just wanted to record our position on that score for now, but I'm sure we'll deal with it internally as we go. Score, please.
Thank you. Okay, so I am adjourning the matter. I will investigate whether there's a judge who understands Afrikaans who will then be in a position to hear the matter, and then the registrar will liaise with you regarding dates. We will be looking at a date either in February or March. It's almost the end of the year, and we are crowded out for the year. I think the dates that will be available for allocation for this matter is either February or March. So the registrar will liaise with you, and the date can then be set. And in that directive, I will indicate whether there's a need to translate documents or not. Thank you. The costs of today are reserved.
It's my pleasure.
Thank you, my lady. As the court
Thank you.
pleases.
The proceedings are adjourned.
Thank you.
As the court pleases, my lady.
The court pleases, my lady.
Thank you.